Okay, we're going to get started. The regular scheduled meeting of the Montezuma County Planning and Zoning Commission is being held in the Commissioners' Meeting Room in the Montezuma County Administrative Offices, 109 West Main, Room 270, Cortez, Colorado. We're going to open with the Pledge of Allegiance, followed by a moment of silence.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, Don, can we please have roll call?
Commissioner Farian,
Here.
Commissioner Hernandez,
Here.
Commissioner Taylor,
Present.
Also present is Don Haley and Jane Duncan of the County Planning Department. Absent is Commissioner Saunders and Commissioner Neergaard.
and Commissioner Lynch.
And Commissioner Lynch, I'm sorry. Please silence your cell phones or turn them off. If you need to take a call or an important call, please step out of the hall to do so. All right. Has the Planning and Zoning Commission reviewed the September 14th meeting minutes?
I have.
Okay.
I
And,
make a motion that we approve those minutes.
okay. Motion was seconded by Commissioner Taylor. And can we have a vote, please?
Commissioner Farian,
Aye.
Commissioner Hernandez,
Aye.
Commissioner Taylor.
Aye.
Okay. No further discussion on the motion. Motion was carried. Vote was unanimous. All right. The Montezuma County Planning Commission welcomes you to this meeting. This board is comprised of members who are tasked at making recommendations to the county commissioners. We are not the decision makers. We encourage public comment after each permit. Persons speaking during public comment will be limited to 3 minutes, or depending on the number of people wishing to speak, it may be reduced at the discretion of the Planning Commission to allow members of all members of the public the opportunity to address their thoughts and concerns. When addressing the commission, please come to the podium, state your name and address for the record prior to providing your comments. Comments to individual applicants are not permitted. Participants may not yield their time to others. And I will be voting tonight. And can we have roll call, please?
Commissioner Farian,
Here.
Commissioner Hernandez,
Here.
Commissioner Taylor.
Present.
Okay, number one, notice is hereby given that the Montezuma County Planning and Zoning Commission will hold a public hearing for the purpose of reviewing and determining recommendations to be made to the Board of County Commissioners regarding a proposed high impact permit application submitted by Raptor Self-Storage LLC on property located at 26304 Road L, Cortez, Colorado, consisting of 3.4 acres more or less, located south of Road L, east of Road 26, situated in Section 24, Township 36 North, Range 16 West, New Mexico Prime Meridian. This is a public hearing. Was a public notice published?
Yes, sir.
Was evidence of letters to the adjoining neighbors and mineral owners submitted?
Yes, sir.
And was the sign posted?
Yes, sir.
Does the applicant want to come forward?
Good evening, Commissioner Farian. Chris
Hello.
Ross here with Raptor Self-Storage. Thanks for having us.
Absolutely. Jane, can we have department findings, please?
Sure. Raptor is seeking to expand their self-storage operation and place additional storage units on the property. Future full build-out is projected to exceed the maximum 12% of the threshold standard, and that's the reason why he's here to apply for the high impact permit. Full build-out is expected to be at 2025.
Okay. Did you have anything else you wanted to add?
If you guys have any questions, go ahead with them.
Go ahead. Did you have anything?
Yes. First, let me congratulate you on that application. I like to see, this is what it looks like. This is the first stage, and this is the build-out. Very well done.
Thank you. That was Becky.
Yeah.
So she's watching right now, I think, and Sean. She especially did an amazing job. I tried to submit a couple through, and she's like, "That's not nice." And then, so she got it looking good.
It helps a lot. Now, with that said, I did take a ride out there. Saw what you have. It's nice and neat and orderly. But looking at what else is going to go in there, I just see it's so unattractive. Have you ever thought about landscaping the front?
The area you think would look nicer would be in front of the current sign container, like the lower area.
Along L, yeah.
Yeah, we, as we just opened a year ago, haven't gotten to that yet, but that is a great idea. And do you have any like suggestions as far as what you think that might be like, or just like more manicured? What are you thinking?
Trees to screen it. That was my thought. Trees to screen that, yeah.
Yeah, I would need to look into irrigation requirements for that kind of a setup. Do you know by chance?
Yeah, you could put some, indigenous trees that survive here, and you have water, obviously, so just some kind of a drip system would work fine.
We actually have no utilities at all, so we're totally
Okay.
off grid.
Okay.
But so it would need to stand on its own. If there are options like that, I'd love to hear about it.
Yeah, I think, so there's water tanks that you can just tap into, and yeah, I'd have to fill up the water tank though, but to me, that's what I would like to see. Yeah. That's all I have.
Okay.
I have no question.
Okay. I've been to the storage unit myself. I thought it was well laid out. I think, me personally, I think it looks fine, especially butting up next to the other industrial areas there. But that's just my opinion, so. And I think that's all I had. Okay. Any other discussion? Okay, then we will open it to public comment. If you'd like to comment, please come to the podium. Okay, seeing none, we'll bring it back to the commission. And if we have no further discussion, I will entertain a motion.
Okay, I'll make a motion to recommend to the County Board of Commissioners to approve the High Impact Permit application submitted by Raptor Self-Storage LLC, based on the following. The proposed use is in conformity with the code. The proposed use shall not generate any significant adverse impacts on other properties in the area, and public utilities and services are available or can be made available to support uses consistent with the proposed zoning. A condition, though, I would make is that there is landscaping on L Avenue Street, so it's screened. And I can't think of any other way to landscape it other than, I don't know. But in my opinion, that's what I think needs to happen.
Now, would that include, because I can't remember, is there a screen on the chain link currently?
So yeah, I was thinking about it. That's a potential option to screen the fence, and that would cover up a lot of the shrubbery and, trying to picture that kind of an angle.
You're double stacked. in
Oh, the
back.
containers?
Yeah,
So they're only
it's the
single stack.
containers that
Sorry, what's that?
It's the containers that I think need to be screened. Yeah.
They are single stacked, but they are up a little higher. So we'll have to go look and see if what we can come up with as far
Okay.
as if we need to do that, and what might actually have an effect on it.
Okay.
Okay.
I second that.
Okay. Second by Commissioner Taylor. Any other discussion on the motion? Okay, then we will call a vote.
Commissioner Farian,
Aye.
Commissioner Hernandez,
Aye.
Commissioner Taylor.
Aye.
All right. Motion was carried, vote was unanimous. Good luck. Thank you. Okay, can we have roll call, please?
Commissioner Farian,
Here.
Commissioner Hernandez,
Here.
Commissioner Taylor,
Present.
All right. Being that we're continuing this, do you still need to read it? Yeah,
the
okay.
public notice, yes, and then we'll
Okay.
need a motion to continue.
So, number 2, notice is hereby given that the Montezuma County Planning and Zoning Commission will hold a public hearing for the purpose of reviewing and determining recommendations to be made to the Board of County Commissioners regarding a proposed amendment application to the Hoch 2-lot minor subdivision and AR 3-9 and heavy industrial rezoning submitted by Daniel and Debbie Hoch on property located TBD Road L, Cortez, Colorado, consisting of 32.91 acres, more or less, located south of Road L, east of Road 26, situated in Section 24, Township 36 North, Range 16 West, New Mexico Prime Meridian. And this one will be continued. So I will entertain a motion to continue this to November.
I move to continue this application to the November hearing meeting.
Okay,
I'll second.
and can we have a vote, please?
Commissioner Farian,
Aye.
Commissioner Hernandez,
Aye.
Commissioner Taylor.
Aye.
Okay. Vote, motion was carried, vote was unanimous. And can we have roll call, please?
Commissioner Farian,
Here.
Commissioner Hernandez,
Here.
Commissioner Taylor.
Present.
All right. Number 3. Notice is hereby given that the Montezuma County Planning and Zoning Commission will hold a public hearing for the purpose of reviewing and determining recommendations to be made to the Board of County Commissioners regarding a proposed high-impact/special use permit application submitted by Ramble Outdoors, Inc., agent for Benny and Sandra Cordova, on property located at TBD Road 31, Dolores, Colorado, consisting of 9.05 acres, more or less, and Conrad and Eva Hoover on property located at 29485 Road M, consisting of 24.12 acres, more or less, both located north of Road M, west of Road 31, situated in Section 9, Township 36 North, Range 16 West, New Mexico Prime Meridian. This is a public hearing. Was the public notice published?
Yes, sir?
Was evidence of letters to the adjoining neighbors and mineral owners submitted?
Yes, sir?
And was the sign posted?
Yes, sir?
Okay, does the applicant want to come forward?
Hi, folks. Dieter Erdman with Ramble Outdoors. Nice to see you again.
Hello. All right. Jane, can we have department findings, please?
Sure. Ramble is proposing to develop and operate a low-density, high-quality private campground, providing a new hospitality option for visitors in Montezuma County. It is actually next door to BLM land, which is Phil's World, and it is against their parking lot.
Okay. Do you have anything else you wanted to add?
I think we've recognized the potential impacts that the campground could have. We've made great effort to try to mitigate those to the best that we can, particularly as it relates to wildfire danger and traffic impacts, but happy to answer any questions.
Okay.
What are we referencing in a hospitality option? Can you explain that one to me? Because didn't see it.
Sure. Well, a private campground by nature is a place for folks to stay and visit, and so we're in the hospitality industry.
Okay.
And this came to us last month or the month before?
2 months
What's
ago,
different?
2 or 3 months
I
ago.
believe it was in August. Right, so, before it had commercial zoning on the small parcel. And the commissioners reviewed the zoning part of that first, and because it was a package deal, they did not get to the high impact permit special use permit. So now the high impact permit special use permit is going through the process, because a special use permit is allowed on AR zoning,
Okay,
and it is not being proposed to be changed to commercial as far as zoning goes.
okay, so it's the high impact that's different this time, okay.
Correct.
I remember last time, my question was the fire. You know, they had one way in, and what are we gonna do if that gets,
Yeah, you bet. I can speak to that for sure. So, we are in the process, two things. So first of all, we spoke with the sheriff, and I actually met with the fire chief out at the property today, which is, I think, about the 4th time I've met with Cortez Fire out at the property to talk about wildfire mitigation and how we're going to work together to do that. And so our plan A is that we are working with the Bureau of Land Management under a right-of-way to allow kind of an access across adjacent BLM land to the Phil's World Trailhead in the event that there's a fire that cuts off the egress, the ability to leave the property. So that would be, kind of a situation where it's let's get up and go and get out of here into a safe zone that is a graveled parking lot that's a couple acres. That appears to be, we've got to go through the process with the Bureau of Land Management, which is going to include a National Environmental Policy Act review. But speaking with the field office and their NEPA coordinator, it seems like it'll be feasible. We've got to do a wildlife survey, and we've got to do a cultural resources survey and those kind of things. But it appears that process could come to conclusion by next spring, when we would be looking to really get going on the construction of the site. Our plan B, which was suggested by the sheriff, would be to create a safe space within the campground, which would basically be denuded, graveled area that would allow people, if they were trapped on the property by a fire, to be picked up by a helicopter or otherwise evacuated. So that's our plan B. That's not our preference. We would actually like to utilize existing infrastructure as a safe zone in the event that something was going to happen. I'll back up and say that we are working with Cortez Fire. So we've hired a fellow named Bruce Short, who's a forester. He's working on a comprehensive wildfire mitigation plan for us, which is going to include thinning and creating defensible space around each campsite. So we are going to go through and thin the property in terms of the density of the forest there, based on Cortez Fire's recommendations for defensible space. So we're working with Cortez Fire, we're working with Bruce Short, and we will have not only a comprehensive wildfire mitigation plan, but also emergency response plan, so that our folks who are operating the campground have a procedure by which they can operate in the event that there's an emergency, like a wildfire.
okay.
So are you going to allow campfires at each campsite?
When there's not a fire ban in place, yes. So what we're providing our guests is called a solo stove, SOLO. That is a stove that has a secondary combustion process, so it reduces smoke and it reduces embers from coming out of the fire. So it's an increase over your standard fire pit in two ways. First of all, you can hang out around it without smelling like a chimney, but also that reduction of the actual smoke and embers from the campfire. Other measures that were taken On site, we're going to have fire extinguishers at each campsite. And we've got basically traffic patterns set up so that any traffic that is exiting the property has the right of way in a two-way traffic situation. So, and there'll be a 4-inch hydrant that'll be installed near the entrance to the property, which, according to Cortez Fire, will be sufficient for any firefighting purposes that they would have.
Is there going to be on-site monitoring, that kind of thing? Or is it self-monitor?
We will have a camp host,
Okay.
yes.
Yeah.
Don, you point to that cistern? Is that little tiny square?
Yeah, the underground cistern, correct
There,
me if
okay.
I'm wrong, Dieter, it's somewhere
Okay.
located.
Right in that area is
Okay.
where we have planned it. Now, again, meeting with Cortez Fire today, they said that was not gonna be something that they would find useful. They said if they had a hydrant at the entrance to the property on County Road M, that would be all that they would need, because they wouldn't be filling up
Okay.
on the property.
So then you will have a hydrant at the entrance?
Correct.
Okay,
That is part of the plan
okay.
with Montezuma Water.
Dawn, forgive me for being dense. You said this application was sent back based on that the commissioners felt that it needed to be a high impact permit to do this. And I'm hearing a couple of different things, and I
Right.
apologize for being dense.
No, that's fine. The
But on what basis
original
did they-
application had rezoning of the 7-acre parcel because it contains all the infrastructure,
Right.
along with the special use high impact permit.
Okay.
But they addressed the zoning issue first, and they did not feel that they wanted to zone that parcel as commercial. Not
Okay.
so much for this issue, but if this should cease to exist, that it may lead to something further in the future
Right.
as a commercial lot. So at that point, they did not review the high impact permit special use permit. They figured because it was a package deal, Ramble had the option to petition the BOCC to review the high impact permit special use permit alone, but trying to pull that out of the package deal was kind of a marginal deal, so that everybody just figured it made more sense to reapply as a standalone high impact permit special use permit on the AR property.
Right. On the yellow outlined, what you have yellow outlined there.
Yeah, so everything you see in here will be in a surveyed, permitted envelope. So the high impact permit special use permit will be pertaining to this whole envelope.
Okay.
Down here at the south is a possible expansion in, I don't know, what would think in 3 to 5 years, 5 to 7 years.
Yeah, at the very soonest 5 years.
Just as an option, but not as a guaranteed phase 2 at this point.
We're not asking for approval of that. That would have to go back through the process in
Right.
terms of looking at a high impact permit.
But the envelope itself, like I say, is surveyed and would be on the plat as the permitted envelope for the high impact permit special use permit.
The BOCC didn't feel that it met the criteria of being commercial because of its AR status?
Yeah, the discussion, the BLM, if they weren't federal, would have to permit their parking lot.
Right.
It's just strictly commercial use right there. But what they didn't want was this leftover parcel in the county, kind of out away from anything else commercial there.
Right.
Should this operation cease
Cease and
to be utilized.
And just with the high-impact special use permit, if this operation does not continue or it ceases to exist, the high-impact special use permit will be null and void, and the property is still AR.
AR.
And if violation is found that they're not meeting the standards that they've set, that permit can be pulled at any
Yes,
time.
it can.
Thank you for
Correct.
the clarification.
Yeah, and the orange part shows the, part there that's on the Hover property. It's roughly 25 acres out of 150, so it's just a fractional part, but, that is possible under the land use code to have two parcels or two parcels of parcels under the guise of one permit. As long as you have it designated with that legal description.
The purpose for the size of the lease on the Hover tract is to provide a buffer between the campground and current land uses that exist down in Simon Draw, which are agricultural. We will fence, as we indicate in the application, the boundary of the campground. So about half of it's currently fenced, and we'll add a fence along the lease boundary there on the Simon Draw. But we leased extra property because the Hovers were willing to lease it to us, and that way it's steep. It's a mesa edge. It's a cliff edge. What we're trying to avoid is any kind of impacts to the neighbor by our use. Essentially, it provides distance for noise carrying. If people want to explore, hopefully they don't go down any further than the fence. But they've got a little ways to go. Again, the vast majority of it actually isn't useful because it's a slope. So I think just an estimate, with the 22 acres, less than half of that's probably, maybe just a little bit more is developable, in our current plan or under a future expansion that again would be reviewed by this commission.
Okay. Any other questions? Okay. All right, then we will open it to public comment. If you'd like to comment, please come forward. State your name and address. Okay. Seeing none, then we will.
No, we've got one.
Oh, I'm sorry. Come on up. I'm sorry, I missed you there.
My comment is mainly to the people that are here, but also the Planning and Zoning Board.
Please state your name and address, ma'am.
Yes, my name is Dina Davis. I live at 11273 County Road 29. And I received this paper in my mailbox. So it's sort of, I found it interesting, and I wanted to come find out what it was about.
Pardon me, Tina, if you would push the
Speaking of that
button,
microphone.
push the
Okay.
button there on.
Yeah.
So
Okay, I'm sorry, I wasn't talking into it. Anyway, I just, I have a little experience with these type of situations, and I'm not on either side of this situation, but I did want to mention a few things. I've been here in Cortez for about 3 years, and when I look around Cortez, and I look around Dolores, and I look around Mancus, I'm a little bit disturbed because I see so many closed businesses. And I see a beautiful area that's having a hard time prospering. And I think that this is one of the most beautiful areas I've ever been in my entire life, and I'm very happy to be here. So when I saw this paper, I thought, well, let me poke my nose in this and see what's going on here. So I just want to say this, and that is, this area is about biking, hiking, and camping. And it used to be about agriculture and hunting and wonderful things like that. But unfortunately, sometimes things change a little bit. And now it's a lot of biking and hiking and camping. So if we want this area to prosper, we have to bring people here. And when people come here, they spend money. They go and they do their camping, and then they go to town, whether it's Mancos or Cortez and Dolores, and they spend money. They go and they go to restaurants, or they go to Walmart, or they go get their camping gear, and they do stuff like that. This type of business that this man wants to do is going to bring people here. And that's going to bring jobs to grandchildren and wives and husbands. And that's how this area is going to prosper. So even though we don't want more traffic and we don't want more cars going up and down our roads, we need that, because that's how we're going to make this area prosper. So thank you for hearing me.
Thank you.
Thank you. Anybody else? Okay. Then I will bring it back to the commission.
I'll make a motion to recommend to the County Board of Commissioners to approve the proposed high-impact special use permit application submitted by Ramble Outdoors, Inc., Agent Benny and Sandra Cordova, and Conrad and Eva Hoover, based on the following. The proposed use is in conformity with the code. The proposed use shall not generate any significant adverse impacts on other property in the area, and public utilities and services are available or can be made available to support uses consistent with the proposed zoning.
Any conditions?
That the fire mitigation, that, you know, you stay on top of that, rascal. And I'm sure they will.
Okay. Any seconds? Okay. All right. How do we proceed from here if there's no second?
Then I guess it dies without a motion.
Because I can't second.
Yeah, you can.
Oh, I can?
Mhm.
Okay.
Yes, you can vote.
Then I will second.
Okay.
And then can we call a vote, please?
Commissioner Farian,
Aye.
Commissioner Hernandez,
Aye.
Commissioner Taylor,
Nay.
Okay. Motion was carried. Vote was 2-1. Good luck.
Thank you very much.
And can I get a roll call, please?
Commissioner Farian,
Here.
Commissioner Hernandez,
Yeah.
Commissioner Taylor.
Present.
All right. Number 4, notice is hereby given that the Montezuma County Planning and Zoning Commission will hold a public hearing for the purpose of reviewing and determining recommendations to be made to the Board of County Commissioners regarding a proposed 4-lot moderate subdivision and rezoning application submitted by Ellis Lewis on property located at 14171 Road 36.75, Mancos, Colorado, consisting of 39.66 acres, more or less, located south and west of Highway 184, situated in Section 34, Township 37 North, Range 14 West, New Mexico Prime Meridian. This is a public hearing. Was the public notice published?
Yes, sir.
Was evidence of letters to the adjoining neighbors and mineral owners submitted?
Yes, sir.
And was the sign posted?
Yes, sir.
The applicant wants to come forward.
Sure.
Hello.
Good evening.
All right, Jane, can we have planning department findings, please?
Yes, sir. The applicant proposes to create a 4-lot moderate subdivision consisting of parcels of varying sizes. The infrastructure is already in, as there are houses already on the property.
Okay. Did you have anything to add?
Yes.
Yep.
Thank you.
I expect the most significant one are the next 2 pages. These 2 pages that have the signatures of my neighbors who support this proposal.
Okay.
What is the, what did you say that was? A petition?
Of people in support.
Do you want me to put it on the viewer or not? Okay, fair enough. Yeah. Just so we've got it, that it's for what it's for. Thank you.
Note that the next document calls for prior approvals, just a history of what's happened with this situation.
Excuse me, can you speak into the mic so we capture this on YouTube land?
This one.
Either one.
Okay, the reason we're here is because the county in 2021
Please speak a little closer to the microphone. Thank you.
alleged that I was in violation of the land use code, largely because I had a fire and I rebuilt the house. And at the time, this was 2016, we were doing just fine building the house, and the stonemason came along. He said, you know, the setback here is 30 feet now, and your house is closer than 30 feet, but you're probably grandfathered. So the next morning, I was down here, and I met with the director of planning. In those days, it was Leanne Milligan, and she reviewed the proposal, what we were doing, and found no problems with it. As I became more familiar with the land use code, I realized that section 9103 expressly deals with a situation like this, where we have 4 houses on a 40-acre parcel. The last house came in there in 1993, I believe. And at least 2 of those homes were there, I guess, in the 50s, judging by what I see in the construction. And so they were a long, long time before. The place was serviced with outhouses, and we had a water tank. When the electricity came on, actually the cabins were in a different location in the early days, and they put them on 4x12s and skidded them up to where the electricity was. So this goes back a long, long way. And in fact, section 9103 expressly deals with the situation where we have a non-conforming use. In this case, the 4 houses on 4 acres, which were in place in 1998 when the code was adopted. And the code, in your papers there, you have a specific reference to the land use code where it exempts those properties from the permit process. So in fact, although Mr. Haley alleged that I was in violation, in fact, I was not in violation. Nevertheless, I applied for, he demanded 2 variances, one for the setback for that house and the other for the fact that the 3 cabins were all on a common leach field. Of course, this was done in 2014, and Mr. Wickstrom did the engineering, and the county commission approved it, and the health department approved it, so that was, neither of those were actually violations of the code. But away we went. What Mr. Haley said was, you're subject to criminal or civil sanctions unless you do a subdivision or a planned unit development. But he says you can't do a subdivision, your houses are too close together. So in fact, I applied for a planned unit development. And the reaction in the community was pretty intense. And I suppose had one of my neighbors come up with a proposal for a planned unit development, I might have objected to it myself. Of course, nobody realized that I was under pressure, under threat of criminal and civil sanctions if I didn't make this application. So I made the application. Planning and zoning found that I met the 3-prong test for approval. Subsequently, the county commission also found that. The problem lies because they put certain conditions upon approval which are contrary to law and totally unacceptable. The worst of it was that they were demanding that I build a left turn lane out on Highway 184, a mile distant from my property. Now, this runs directly into conflict with the United States Supreme Court. And if you look on your documents there, there's one of those refers to the rulings of the United States Supreme Court. Basically, the rule is this: it's a 2-pronged test. Any demands that are made, there must be a nexus, if you will. In other words, there needs to be a direct correlation between the impact of the proposal and the restrictions that are placed. The second test is a test of proportionality. In other words, it's improper to demand a left turn lane or anything that's distant from the property and not balanced by the impact of the proposal. Of course, in this case, we already have 4 houses on the parcel. We're doing a 4-lot subdivision. There is no need, nor is it appropriate, to place restrictions on my property that don't apply to other properties within the community. So in addition to this left turn lane demand, the other demand was that I be prohibited from building any additional residences on the 3 lots, one of which already has 2 houses on it. The courts have held that when you make a specific demand of an individual, they become a party of one. This is a constitutional violation. So my dilemma is, I'm a trustee. I'm responsible for this estate, and I cannot enter into an agreement which reduces the value of the property, especially when this demand is inconsistent with any other properties. Namely, the demand, one of the demands was that on the plat, there be language that required me to get clearance from CDOT before I could build any house. Now, that's over the top. That's not appropriate. And I will not sign a document with that. And We've been down through the process here. I filed a petition for reconsideration. Mr. Haley sent me an email that says the only problem the county has with your proposal is that you need to make a separate leach field for parcel 2. In response to that assurance, Mr. Wickstrom came out, we put in the leach field. Unfortunately, the demand's now changed. The last communication I got from Mr. Haley was certified mail demanding that I agree to those restrictions or be subject to criminal and civil sanctions or start tearing down the houses. Now, this whole situation comes about under false allegations. These were not violations. And even if they were violations, the land use code is explicit in what is the responsibility of the director if he comes into the knowledge of a violation. This is not just land use code, this is Colorado statute. You are required to give written notice of what the violation is, the amount of time allowed to make that repair or adjustment. We never did that. So when I came before planning and zoning, the complaint was that you have to have 2 variances for the 2 alleged violations. When I came before county commission, now he changed the tune. Now the tune is you're here before because you have 4 houses on your lot, which is a non-conforming, does not conform to the land use code. The land use code expressly states that those houses that are in place when the day they adopt the code are grandfathered, they are not subject to the permit process. The evidence for that, and those quotes out of the land use code are in those packets that you have. So at this point, I want to get this done. I've been tied up for 3 years. I've got $30,000 out of pocket. I have nothing to show for it but a threat of criminal sanctions. We can resolve this whole business and all of these violations by the county of the land use code by simply approving this 4-lot subdivision without conditions, and I ask you to do that.
Okay. So are there plans to build another house?
I have no plans at this point to do that. Here's part of my problem. I'm 81 years old. I've acknowledged the possibility that I'm mortal. And I find that with this 40 acres...
Sir, please speak into the microphone.
Okay. With this 40 acres, it's a full-time job. You know, even though 2 of those houses are new houses, it's still a full-time job. And I don't want my trustee to have to deal with this property. We'll take a beating on this if we have to sell 40 acres as 1 unit. It's appropriate to divide it into 4 lots. The 4 houses are there. The impact in the community is nil. The houses are already there. The people are already living in them. They've been there for 40 years.
Okay.
So all these 4 houses, Don.
Yeah, if you want, we can clear this up real quick.
Okay,
This is imagery from 2010. If you look up here at the top,
okay.
that's a grandfathered house.
2010?
And this is 2010 imagery. So
That's-
that
That's
that
what-
existed at that location, at that building footprint. Land use code says if it burns down more than 50%, you can't expand the footprint, and you
Right.
obviously can't move it.
Right.
So if you look at the screen, you can see where the house went. It went from grandfathered in
Okay,
to twice as big,
this is where I
too
was
close
going.
to the property line,
In a different location.
making it a non-compliant parcel.
So it moved.
So that's how this all got started.
Okay, that makes sense.
The only issue here is, this was not what the allegation was. This is not what I responded to. I keep getting faced with a different set of demands. How can I possibly meet demands that change? And they change and they change. And now he contends, I'll refer you to the good book here. You don't put new wine in old wine skins. And you don't build a new house on an old foundation. In this case, we built it as close as seemed practical so that we could use the existing septic tank and the water service and the electric service. There's no demand that the house be placed on exactly the same foundation. In fact, this house is 879 square feet. I'm sorry, I misspoke, I think. Anyway, because I was dealing with State Farm, and I thought State Farm demanded that I build an exact square footage house as the one that was there, that's what we did. I didn't realize that the land use code that said that it had to be basically the same size house, but it was the same size house. It's inappropriate to change the rules and change the allegations at each step of the way. And now we're in a situation where planning and zoning found it was in compliance. The county commission found it was in compliance. It is never appropriate to demand $1 million left turn lane a mile away on the highway. That was bogus. And CDOT had noticed twice before this prior proceeding, and the land use code expressly states they must respond within 21 days. They did not respond within the 21 days. In fact, they were notified weeks earlier, according to records from county records, which I have. So they had plenty of notice. They failed to respond. Then 2 days after the final day for them to respond, and the code says, failure to respond shall be deemed approval. It's not a gray area. Nevertheless, Mr. Haley, 2 days after the past due date, called him up. And a lady who's no longer in charge there sent an email and said, if you're going to build 8 houses, you have to build a land use code. Clearly, she wasn't even looking at the document. So I went through that whole process. I made formal application for an access permit, and they made recommendations that I had to do the access permit. Now, in the notice that we've just given them here, if you read their response, all they did was make 2 statements of facts. One, they acknowledged that I applied for the access permit back in December for 22, and they also acknowledge or state that they're waiting for a level 2 traffic analysis. A level 2 traffic analysis is $10,000 or more. There's no excuse for this. I paid an engineer and prepared. It wasn't 10,000, it was about 1765 to do the traffic count out there and give a report, which I delivered to CDOT. I have their acknowledgement that they received it. If you read those documents there, you'll see that the state highway code sets out specific timelines for CDOT to respond. CDOT did not respond timely in any case, and now they're not even making an assertion that any demand is being made of me. So that's no longer relevant.
So just to be clear on the screen, you'll see the response October 6th of this year. CDOT states that Mr. Lewis did submit an incomplete application. They're still waiting for a level 2 traffic assessment.
So that's why they didn't respond.
And
So it's just a
our issue, we don't control CDOT. We did not demand turn lanes.
On the
CDOT
contrary,
is in charge of safety. The county roads are for the public safety. So we coordinate with CDOT. Their demands on their highways is their own issue. The county does not control that, assess that. All we did on the original plat was if you want to build on Lot 4, which had been approved verbally, is contact CDOT. The other condition was in order to subdivide, you can't have a septic system on one parcel, cross over and extend onto another parcel. And so that was one of the conditions, is that the Lot 2 get its own leach field, because it already had a septic tank. That was complied with, and nothing else changed from BOCC from start to finish.
And that was 2001.
2021.
Right,
2021.
21.
I'm sorry, 21.
But the
2021.
initial contact happened in 2019 on the extra houses on the
okay.
property.
So my question then is how, if in the previous photographs, you said that that house changed in 2010.
No,
So-
that was 2010 imagery.
When did it change?
So I was showing you the 2010 imagery
Imagery, right.
versus 2021
Who was
imagery.
this, right, present
It
imagery
burned down in 16 and was rebuilt in a different spot.
in a different spot. So why didn't the previous P&Z and the BOCC see that that was a violation of the land use code? You can't move it.
Well, but what, by subdividing it to 4 lots, he then complied.
Mm-hmm.
And the condition was that if that commission granted the 4 lots, right?
Okay.
The condition, there were 2 conditions to that, is what I'm gathering, that the leach field needed to be fixed.
Okay.
And that.
Which has been complied with.
Correct. And that CDOT is.
Notified.
Is, it sounds like to me, a traffic study, and they are consulted in the event that Lot 4 is to be built on.
Okay.
CDOT requires that of any application, do they not?
Oh, yeah, they get every agency, I mean, they get
This is
every
not-
notice.
This is not specific to Mr. Ellis.
Oh, no. Every application goes to about 75 different departments and agencies.
okay, here's the fundamental issue. Let's assume, just for the sake of argument here, that CDOT has a right to demand $1 million
Turn lane.
turn lane for something that has no impact. The real key is on what Mr. Haley demanded was that on my plat, there be a restriction prohibiting from building under the guise that this, and they repeatedly tell me, this applies to the whole neighborhood. Everybody south on Road 37 is under this pressure. The key situation here is, if that's true, there is absolutely no basis for demanding that it be placed on the plat. If it applies to everyone, it applies to everyone. And when you make a single person, one person in the whole neighborhood will forever have restrictions on his property that will not apply to anybody else. Who knows, CDOT might do a left turn lane. They really should. The county and CDOT appropriately will get behind this remedy for this hazardous intersection. We now have a fatality in this intersection. Mr. Jim Wilson died after all of this nonsense was in play, because he got rear-ended about at 70 miles an hour. This needs attention, but it's not, under any circumstances, my responsibility to be doing the work of the county and of the state highway department. That's their turf out there. And Mr. Haley, March 11, 2021, stood right here, and it's in your packet, the quote, "CDOT has nothing to do with this." His words.
So Don, I mean.
Yeah,
when
we're not here to have CDOT control, or
no,
not control.
No, that's, yeah, I totally understand that. They're their own entity, they're in control of their own road. Right?
Correct.
And all we have to do is, well, per our land use code, is say, you need to make contact with them as part of all the other applicants, or not the applicants, but the departments that this application is gonna go to.
Yeah.
Okay, end of story.
Correct.
There's one
Wait a
more.
minute, Mr. Ellis, wait a minute, okay?
Yeah.
The house issue that you showed before, we don't care about that setback. That's not.
That
it's
has been
grandfathered or-
granted a variance,
It's
and
variance.
so it's compliant as it sits.
A variance was granted.
Correct.
Okay. So we're here because there's two things that need to be resolved for this 4-lot subdivision. The leach field,
That's resolved.
that's resolved. They could put it in another thing, another area.
Yep.
Okay, and then the other one was,
Is the compliance
With-
of having no more than 2 houses on one parcel. So
Two
lot
houses.
1 has 2 houses.
2 houses. Okay, and that, because lot 1 is only how
It's
many
the
acres?
top. Yeah, 6.87 acres.
6.8, and you can't, and it's gotta be 35 to have 2.
No.
No.
No, it has two. It
That's
already
a
has two.
It's a 3-acre minimum, but you're allowed 2 residences if you can make it fit with the septic systems. So he's got one
That
cabin,
house
one
there.
house is there,
Right,
and this one's up here,
right. And they both have to have their own leach field.
and they're fine.
Okay, then they're okay.
So this house
Okay,
had its septic tank here, but it was using this leach field. It has
Okay.
since had a leach field installed.
okay.
So lot 2 has 1 house, and that is this lot.
It has to create its own leach field.
Yeah, it's got
already
its
there.
own leach field, it's there, it's fine too.
It's
It's
fine,
done.
okay.
Lot 3 is Mr. Ellis's house.
Okay.
It's got its own utilities, house
Okay.
and
Okay.
septic. Lot 4 here at the bottom has a tractor shed here and nothing else.
As convoluted as this permit application has been, and the I said, you said, he said, she said, I'm boiling down to 3 issues. And because as commissioners, we've got to assess what's the
Gotta
fairest
narrow it.
and what is it. We have 2 residents on one lot that has not been resolved. We have CDOT has not been resolved, and those are am I understanding that right? There's only 2 issues left. The one lot number 1 has 2 residential houses on it.
Which would be appropriate.
Which is fine.
Which is okay.
It's been varianced in.
It doesn't have to have.
Okay.
If lot
So
1
we're-
is,
We're
if
boiled down to the issues with CDOT.
the issues are not really us with CDOT.
No, correct,
Yeah.
but his permitting
Right.
roadblocks is CDOT and their left turn lane.
Right, so these 4 lots, as is with the residences, is fine. Like
Okay,
he says, they've basically been there for 40 years.
okay.
But there is no.
Traffic's
subdivision.
no
There
different.
are no lots currently.
Right.
Yeah.
They're gonna make 4 lots.
So
Exactly.
then, what you guys are looking at is, as is fine. CDOT, fine. If he wants to expand and put more residences there, you have to determine, if Mr. Lewis has legitimate, adequate access per the land use code to add more impact through this existing development that is not an approved subdivision. So from what Mr. Lewis has given to us and stated is that his access is here on P2 to his road, 36.75, into the property here for these lots, to his house there. So this is a maximum of a 30-foot wide easement,
Okay. 30 feet,
30 feet,
which is a red road, not a green road. Green road 60, right?
right.
Okay.
And so a major development requires 60-foot easement.
Yeah.
So that was the stipulation discussions before, is these 4 houses are using these roads, which ones and how, we can't control. It's rather new development should be approved to occur using these accesses, and rather these accesses meet the land use code for any expansion.
Okay.
So seemingly that's why the restriction was placed, or the condition that, A, it's a 30-foot easement, an unmaintained road, adding additional residences to a subdivision already
It,
would,
it's a non-county maintained road.
It's red road.
right.
Okay.
So that, because of those reasons, and along with CDOT's report, right? Those were the conditions that were made to approving this subdivision, to a 4-lot subdivision with those specific conditions, correct?
Correct.
Okay,
I see the
gentlemen,
road being a bigger issue then.
when I appeared before the county commission, Commissioner Stevenson twice told me, because of this variance we're approving, you are in compliance with the land use code. Quote, you are in compliance with the land use code. That was insufficient. I relied upon that. Mr. Haley decided to the contrary. In other words, he went directly.
What was in compliance? The setbacks? That was it? That's what they got the variance for? That you're referring to?
The approved 4-lot subdivision was approved.
Okay.
It was approved with
It was
the
never.
conditions.
With the
It
conditions.
had one plat note. There was a condition to the approval, which was a septic leach field, which was resolved.
Okay.
There's one plat note on there that if you want to build on lot 4, contact CDOT
Okay,
for approval.
okay.
And then,
And then the plat was never signed.
The plat was never signed because,
From-
number one, what he's not ignoring here is that the CC, they demanded in the CCNRs that I be prohibited from ever building a second house on any of my lots, even though the lot 1 has 2 houses on it. Okay, now that's a condition that is not applied to anybody else in the county. This is a unique demand, and it is not supported as the law requires.
If I may ask you, you say it's not been demanded of anyone else. How are you aware of that? I'm just
Well-
curious, because I'm aware of quite a few offhand. How many left turn lanes, egress, ingress, has been demanded of people.
and lack of expansion
And
due to
so I'm
access.
I'm curious, who are you referring to?
Well,
Do you have a
just-
subject matter that
no,
somebody?
I'm referring to the land use code. If you read the land use code, and we could quote Mr. Haley on this, that every parcel, it doesn't even restrict the size of the parcels. In this case, all of my properties are larger than the minimum lot standard.
Okay, but you're not, you were referring to other people not having the same rules applied, and I'm curious to know what people you're referring to.
Well, anybody that's under the code, any person that, if you read the land use code, it expressly states that you can have an accessory building, namely a residence, not to exceed 2,000 square feet.
But there are conditions added to expansion of properties in the land use code that put limitations on them.
And, for example,
So I'm just thinking off the top of my head, adding specific reasons why a property can no longer be or cannot further be developed, or added multiple like segmentation or segmenting, things like that, where you have to propose the full development from the beginning, okay? So there are those limitations out there that it's, to me, the last commission saw fit that the access to your property was sufficient for what it is, but not sufficient for future growth.
well, we could quote Mr. Haley from March 11, 2021, when he states at that point, it was a high impact proposal because it was a planned unit development. And quote, he said, "This property is served by 3 roads, P1, P2, and P3, each of those on a 30-foot easement, whereas the usual high-impact subdivision has only one access road of 60 feet. Therefore, this meets the criteria."
And
It's all words.
consequently, the P and Z Commission disagreed with me and denied a PUD and said to come back with a subdivision application.
Well, interesting.
I need
History is,
I need to ask a question. Did I hear you say that your property, this property has CC&Rs on it?
that's a part of the process. Anytime you do a subdivision,
Oh, no, okay, no, okay, but not currently, not currently.
they have to be put on.
Okay, that's fine.
Okay,
Then I misunderstood what
and-
you said.
and that's the
Okay,
difficulty
okay,
I
we're good,
have.
We're good, we're good.
And if we go right back to the fundamental issue, when the county commissioner assures me that I am not in violation of the code, I should be able to rely upon that. Yes?
The land use code has different interpretations, but it comes back to different commissions and their interpretation on it. There is a lot of black and white in it. There's other portions of it that are
Very gray.
that are gray. So I just want to be clear. The 4-lot subdivision was approved at one point with the condition that the septic be fixed and that you contact CDOT.
No, the septic was done before they
Okay,
approved
well,
it,
the
I
septic,
believe.
never mind,
Okay.
but
No,
you
because
contacted,
Don told me that the only, quote, the only issue the county has with your development is that separate leach field. I relied upon that. And even Craig Wickstrom sent me an email and said, looks like you've got things resolved. And we proceeded to do the engineering and do the install on the leach field. It's not an issue. The issue is it appropriate for this body to recommend to the county commission and for the county commission to, who relies upon your recommendation,
Okay.
to make demands that are unconstitutional. These are violations of the Fifth Amendment to the Constitution, a taking of property. I already gave up 14,800 square feet of land because this body demanded that as a condition of supporting the proposal. No compensation whatsoever. I gave up land and gained nothing except a hard time. And the gentleman back here who is going to get up and speak to you has filed a complaint against me. When we came before the county commission, Mr. Boswell and Mr. Graham hired Mr. McCabe to stand in opposition. Now, Mr. Boswell has assaulted me, physically
Okay,
assaulted me.
so those are out of our purview.
Yeah.
And just to be clear, I don't make any demands, I don't make any conditions, I don't get a vote.
Can I read this little highlighted section?
Yeah, this is from the county commissioners meeting on, the commissioner meeting minutes, May 18th, 2021, on the public hearing.
In those minutes, it states, hearing no further public comment, that the portion of the hearing was closed. After hearing all evidence presented, Commissioner Lindsay moved to approve the 4-lot moderate subdivision that is already there, and to include the contingencies by the planning and zoning that no new additional residences on the lots 1, 2, and 3, and the plat notes on lot 4, that no new residences be built without the approval of CDOT. This was seconded by Commissioner Stevenson and carried.
Correct.
Now the
So,
question-
so the bottom line where we're at here is the whole issue is CDOT.
And
those are-
CDOT has no jurisdiction over these proceedings.
I understand where you're coming from, and I appreciate where you're coming from, I do. Unfortunately, because they are state and we are governed by state, county and state, that is a regulation that is required that we must follow. And that's the position that we're in, that we have to follow.
Okay, so the demand was that I make application. We have proof, positive, you just saw it, that I made the application. I made an application for an access permit. That's all that was required. That has been accomplished. There are no remaining issues here.
Well, according to CDOT, you did not, the application was incomplete, correct?
That's what it
Then,
says.
then it's not an application.
Okay, read the paperwork about state code and
So we need to move on from CDOT, because we're not gonna worry about
Well, yeah,
CDOT.
then we have no jurisdiction
And
over
state
CDOT. I
code.
mean,
So what you need to look at is access on P2
Okay,
is what is given as his deeded access to 36.75 on his property for the subdivision.
okay.
okay,
So-
if you would, in your packet that I gave you, there's a document titled at the top, Alleged Violations of the Land Use Code. Okay,
So we're looking at our new application now?
no.
Yes, we are. You withdrew your old application.
Oh.
This is the new application.
Yes,
And the
yes.
P and Z commissioners need to evaluate this access to your property to see if they deem that it fits the land use code for more houses or the current amount of houses, to approve a 4-lot moderate subdivision or not.
Or if restrictions need to be
Okay.
applied.
Or, and with any conditions that you deem appropriate.
So, Mr. Haley sent me an email and said the only remaining issue in your packet is this issue over road access. And he referred me to the County Road Department Road Superintendent, Rob Engelhardt. And I quote, Ellis, as we discussed last week, it's my opinion that Section 5305.5, roads, states that the preliminary plan shall be drawn to county standards. This doesn't necessarily require that a road to be built to those standards. The road department would require it to be built according to county standard if it is to be considered for a green road status at some point. If there are no future green plans, then it is considered a private road and we would have no jurisdiction over it. I suggest you follow suit by building your roads according to all other existing roads or plans by others and designate them as red. So the road issue is not an issue. And
That is the recommendation from the road department, not on land use code easement width.
An easement
okay, so-
width is
Yeah,
60 feet.
He's in charge of the road, that's it. I mean, I know 60, if it's a green road, it's gotta be 60 feet.
Yeah,
I
but
mean, I have that access.
All easements are 60 foot.
And these are only 30.
Not red, not red roads.
Hold on. We will open it to public comment.
Not red roads. Red roads don't have to be 60, because they're not maintained.
No, but if it's a access to a major subdivision,
Okay, but then it can't be a red road or be the width of a red road, because it's gonna have to eventually become a green road, and it has to be 60 feet, correct?
it just calls for adequate access for the subdivision. You are to determine if
What's
that's
that?
adequate
So
for currently it's adequate, obviously. It's been operating for decades.
But it has
Now-
been a 4 lot.
Now, can it sustain more?
Yeah,
if there's future build, can it sustain more, right? Because if you put a 4 lot in there, okay, 4 lot subdivision,
Correct.
right? Then he's compliant with the land use code
correct?
from that standpoint. But the future growth is the concern on that on that 30-foot access.
The future what?
The future growth. So more houses or more housing on each of the individual lots, which is what we have
Oh,
to
I see.
consider.
I see.
Why they put the restrictions on that, right? If the restriction is you cannot build on you cannot build on number 4 and add any additional housing
Housing.
to the other lots, right? Because you're on a 30-foot access.
Yeah, but the way Don showed it, it was, if you build on that lot 4, your access, it's a CDOT thing, not a county.
They're referring that
Right,
out to the
because
highway, right?
there currently is no house on what would be lot 4.
Correct.
So
So
then,
that's
And
why
the
they
o-
said,
the other issue to
if you're
look-
gonna build
Yeah.
on 4, then you have to talk to CDOT.
refer
So
to
if you
CDOT.
don't build on lot 4, you don't have to talk to CDOT. If you don't build on lot 4, we don't have to worry about P2.
Right, if there is no potential for any other growth, then essentially that was approved already,
Okay.
right? But Mr. Lewis here is upset because there were the restrictions placed on the plat and on the agreement that he could not add any additional housing to any of the lots. And then if he built on lot 4, he had to contact CDOT,
Right,
right?
right.
So then we have to determine if we think that P2 is sufficient for, which I think we can agree, it's sufficient for what's there,
Okay, because it's there.
right? But the question then comes to, are there restrictions for future growth of that subdivision?
Yes, there is, for his subdivision, yes, because it'd be lot 4 and CDOT approval.
So that's where Mr. Lewis is, that's the contention here.
Yes, exactly. Now, let me say this. It's been 2 years plus since CDOT made this assertion that if you build 8 houses, quote, 8 houses, you need to make an access permit. In fact, 2 additional homes have been built in this neighborhood subsequent to that with no issues, no access permits.
And both were
Whatsoever.
directed to contact CDOT, both contacted CDOT, CDOT gave approval.
Because it was basically a single lot.
So what happens, CDOT, normally in the rest of the county, state, I don't know, they have indicated to us, we have directed to all the realtors that there's an issue on Road 37. Everybody's directed, you contact CDOT first. If you're just building a house, There is no agency notice to CDOT. If you're developing a subdivision, you are now a developer, and you are required to contact CDOT, and CDOT reviews the development and analyzes it. Now, if they haven't taken care of that access for 30 years, then that's a problem.
Potential problem, yeah.
Okay, let me read from Planning and Zoning Minutes, March 11. P&Z addressed the issues that public comment brought forth. CDOT access. They are not a part of this project. There is a distance limitation on CDOT's authority to require certain things, and the planning department took all issues into consideration. Semicolon. Road access. 24 feet of surface area is required for road access of a major development such as this. This is the planned unit development. The planning director stated, there are 3 access roads to this property, P1, P2, and P3, each one with a 30-foot easement which offsets the fact of a major subdivision usually only having one access road. Now, to get some history on this, these properties were developed by Mr. Glenn Gentry back in, there's, I can tell, late 70s, early 80s. I've reviewed almost all of the deeds and attachments, etc., and they are consistent. It's either in the language of the deed or it's in an attachment like it is with Mr. Boswell's property here. And I have the exact document. So they contain 2 easements. One easement is an easement to access Road 37, unspecified. Just an easement out to Road 37 or 184. The second easement is an easement on each parcel for a roadway. Okay, so each and every property has 2 easements. One easement is a right to access the highway. The other easement is the right of others to access the highway over your property. Now, when Mr. Gentry developed the property, he put that language into every document, and he specified a center line from a point to a point, and that the easements would be 15 feet on either side of that center line. And if you look at the maps,
Okay, so there's a 30-foot easement that's been set by the original developer. Okay. Okay.
Which is the P2.
So, yeah, but what that tells me is that there was no intention of ever allowing anything greater to grow, because I'm limiting to you 30 feet for an access easement. I mean, we're speculating, but
so it's a question of, are these public roads or are these private roads? Private roads is a term of art. That means that the county does not maintain, takes no responsibility for those roads, as is stated by the road superintendent. Now, here I would quote from the county attorney's email to Mr. Boswell here,
okay.
citing Colorado case law, quote, "The ultimate distinction between a public road and a private easement, however acquired, is that the private easement can be and is limited to specific individuals and or specific uses, while a public road is open to all members of the public for any uses consistent with the dimensions, type of surface, and location of the roadway. There's no logical way to advise the members of the public as to which portions of the public roads they travel are subject to specific historic uses, much less to enforce the use of the roads for only those limited purposes. Thus, we conclude that once a road has been declared to be public, all uses that are permissible to the public under the laws of the state are permissible uses. In other words, these are public highways, road P1, P2, P3, which can be used by anyone. Now, if you look at this map,
I disagree with that statement. They're not public, or they're not used by any. Don, is that square, oh, go back to that
Oh,
picture.
sorry.
Go back to that last picture. That's red square. That is a major subdivision that this,
It's a major development.
major development.
Not
Just
built-
that square,
It's not permitted as a
just that square. Nothing outside of that square. Okay, so what Mr. Ellis has is he has an appendage that sits outside of that square. Okay, so I'm just trying to figure out, so all those roads that are in that development were granted as public, as private roads for the people that live in that subdivision, because they're private. They're
On the
private.
contra- on
They're
the con-
private,
no, sir, they are not.
because
private.
of that subdivision. Hold on, Mr.
That's
Ellis,
not-
hold on. There, other people using those roads just because they are. I'd like to see that subdivision, what those.
It was never an
easements are.
approved subdivision, it was just built.
Oh, okay. Well,
That-
but there's gotta be something in writing that
Prior-
states
prior-
these roads are easements for a single purpose.
But that's not what it says.
I'd like to see
The
that.
the deeds, each one, I will find you,
But access to, access to a major subdivision is a minimum of 60 feet.
okay, gentlemen, if you look at the map here, you have small versions of this. You'll excuse me if I step away from this unless I can carry it. I'll carry it. Okay. So, as you look at this survey right here,
Please speak into the mic, sir.
sorry. If you look at the survey here, you'll see this area right here is the land that was deeded to Mr. Boswell because of the planning and zoning demanded that I do that as a condition of approval. Now, if you look up here,
So it butts up there, but it's,
look at the very top at the corner. It says 30-foot roadway easement, Book 536, page 262. Look where the road is. But we discovered when the survey was done that the fence was actually on my property. The easement is on the other side. And
That
it's
doesn't
reflected
surprise
in
me.
one of those maps that I gave you,
that doesn't surprise me.
that there's a 30
So,
foot.
so that 36.75 isn't the issue. It's
but-
to get to that area, P1, P2, or P3.
Which means you have to traverse that subdivision
Yes.
that was never permitted.
And-
Is access
land use.
adequate to promote and uphold more development?
Right.
And that building
see
at
that.
this point is how many lots are available to be built on at this point?
One.
One lot. So we're talking about,
Four.
well, but.
Lot four.
Lot four.
Yeah.
Where I'm talking about the impact of having one residential
Right,
put in there.
yeah, because here's Lot 2. The Lake Irrigation Company has this high water line setback that you can't build within that,
Right.
this area. So trying to squeeze a house and a septic in there is gonna be
There's
pretty,
not a whole lot of land left.
right.
There's room on lot 3 to build.
So Lot 3 is Mr. Lewis's
Personal
house,
residence. Okay.
and then you have
Three.
Lot 4.
Lot four seems to be the issue, and I'm with you on that. Okay, you're gonna add one more structure.
Right.
What's the big deal on that road?
Right.
Now, my concern is that the P1, P2, and P3 are roads designated for that subdivision, and that they're not private for anybody else outside of there.
It
People
could
have
be-
been
it could
using
be-
them,
It could
obviously.
be construed as that very well. in a court of law, I understand where you're going. It could be construed that way.
Yeah. So, I mean, how do you, we can't give permission for something that could be illegal.
Say again?
Could be illegal. He may not have the right to use P1, P2, P3.
Not according to the county attorney.
What?
Here's the rule that he directed folks to.
Our county attorney said it was all right? Don?
I don't know, that's a whole nother lawsuit
That's
outside
what's
of
jumping out
our
at me,
anything.
And the only reason I bring it up, because I have that very scenario where I live.
Yeah, that's
What's this?
a legal
An easement for
position.
purpose of ingress and egress, section 1437, just commencing.
Okay, here's what,
So this is the easement deed to Mr. Lewis's property.
Direction, along existing roadway up northwest going track. Page 2, this running, okay, this is an easement running north.
Northerly
So this is a major one. This is in P1, P2.
So then, for clarification, Mr. Lewis sent me this email that
Okay, Boswell's attorney says, Boswell attorney says.
another property owner's attorney says that that easement is on P2.
Boswell attorney says it is on P2.
I agree, there is a specific easement allocated to the 40-acre parcel by virtue of that document. What I want to refer you to here now is
Boswell's attorney,
Exhibit A
unless he's a surveyor, I doubt that, Doctor.
to,
So if your specific easement is P2, then, that then negates P1 and P3 for access of this subdivision.
Subdivision.
It would be P2 only, which would bring us back to the expansion of of future builds in that subdivision
Subdivision.
would need to be reassessed because of the access through P2.
please allow me to read the recorded document, which was Exhibit A to Mr. Boswell's deed, which is the property on P1. I'll read the whole thing. Tract 1, more described, no, that's it. Tract 2, a non-exclusive easement for ingress and egress for a roadway to State Highway 184. And then it calls it out. Now, this is not a specific right-of-way for the people who live in the community. And even if it were, logic defies this, because Mr. Gentry owned the 40 acres, which I now own. And you'll notice that
That's
in
a
your
lot.
packet, you have a
So
map.
That is a lot, 600
So
feet,
just to be
700
clear to
That's a
you
lot.
guys, Mr. Boswell lives on the south, or the far west end of P1. So this easement is strictly for P1.
For P1.
On the contrary.
How come it said P2?
On the contrary, read the document. This is not an easement for Mr. Boswell to access the highway. This is an easement, non-exclusive easement, for a roadway. And each and every property that was divided out here bears this consistent language. Those easements are not designated for any particular individual.
They have meets and bounds.
I'd say they're not designated.
They have to be, they have meets and bounds.
They have a legal description.
Okay, so each and every property has this same, this down here.
That's the one I'm looking at right here. I'm looking at that right now.
Okay. So you see,
It's on the screen.
Is that easements in question in current litigation between you and Boswell at this point?
well, he is.
I'm not asking for particulars, just is it in litigation?
Yes, it is.
He filed a complaint seeking injunction to prohibit me from working on the road.
Okay.
And speaking of.
That's all I needed to know.
Yeah. And
Like
we're not covering that.
Right.
So this is a map of this subdivision, quote unquote. All right? Now, if you notice, most of the homes are beyond this point because 36.7
I wouldn't say most of
goes
the
up
homes,
here.
a few homes.
And there are houses all along there,
Uh-huh,
plus there are houses out here. Plus we have the houses on Road P3. The result of that is Road P3 carries the majority of the traffic. P2 has some problems with it. Right down here, there's a blind car. In other words, an oncoming car, because it's so steep, you can't see that oncoming car. So it's kind of a risky situation. P1 is pretty good, and Mr. Mira, who lives down here, works this road right here. Mr. Boswell and his neighbors work this road from here. Now, I've been here going on 13 years, and in the past, my partner, Zelfa Gentry, advised me that she provided a tractor. It's a volunteer situation, maintaining the roads. In other words, we pass the hat and get a fund for plowing the snow, but there's no money collected to maintain the road. It's kind of burdens on the person who lives at the end of the road. In this case, that happens to be me. So what I did last year is I spent $10,000.
Mr. Ellis, we're familiar with this conversation because we had this same conversation when you applied last time, as far as what your inputs were into that road. I appreciate that, and because for the ability to move forward here on this, I would like to ask the chairman if he'd put it forth to the public for their comments. I've heard what I need to hear.
I'm with you. I'm with
Okay.
you.
And I appreciate that.
I think you're mistaken, if I may.
Go ahead.
Because when I was here 3 years ago, or March of 2011, this work wasn't done. This work I did last year.
You've stated that to us in the last permit application that you came before us with,
No,
which was last year. Yes, you did.
okay, well,
So,
so let me carry on. Here's what I've been,
21, sorry.
here's what I've done on the roads.
How come I don't remember that?
Because I live here, and I normally drive this way, down P3. I've graded this road. The only difference between a ditch and a road is the crown in the road. And we've been in a situation here where if you meet a vehicle, you have to pull off into somebody's driveway and stop for the other vehicle to pass.
Okay.
So I've focused my efforts on P3 in terms of creating a crown on the road. There are culverts under the road in 3 places. And
okay, sir, I think we need to get back to the pertinent information here, okay? And that is determining whether or not the access is sufficient, okay?
okay.
For future growth of that property, because that was the restriction that we're currently contemplating here, okay? It's a 30-foot access, that's it. Regardless of the condition of the road, it's a 30-foot access.
I want to take it one step further. I want to know that he has a right to use those roads.
And
That was the deed that I showed you. His deed,
His deed on P2.
His
His
deed?
P2.
Okay, show me that. Again, please. That's Mr. Ellis's deed.
that's his
Easement.
easement deed.
Because there's a section, okay, that's just commencing at this northwest corner of tract described, so that's gotta be this corner, this subdivision.
Let me
That's
quote,
running
Mr.
northerly
Ellis,
direction,
please wait.
along the road, northerly direction, that the tract described in book, so I'm gonna assume that 536 is this tract.
Right.
Page that they're thence running in an easterly direction along said roadway to 37. This is 37.
oh,
But he doesn't say how far to go up
Right.
commencing, so, well, it does too. 'Cause
Well,
it
it's
says he's gotta
southwest
get-
corner.
He's gotta get to 37. He's gotta get to 37, and it does say that. Thence running easterly direction along existing roadway 237. Doesn't say that that's 1 or 2 or 3. Doesn't say P1, P2, because it doesn't give you a distance from this southwest
So to
corner.
kind of interject from something outside of us is from their other case pending court, the document showed that his access was P2.
P2.
Okay, but it's not.
And that was provided by Mr. Lewis.
It is not
Mr.
limited to
Boswell,
that.
who is,
No,
No,
Mr.
Mr. Lewis.
Oh, Mr. Lewis, okay.
Mr.
Well,
Lewis,
okay,
emailed
again,
that to us.
this easement says he has a right to go from this edge of the road over to to 37. Doesn't say which one he could use, 2, 3, or 1. With this deed that you just had on there, doesn't show, doesn't say. But he does have the right to get over there.
So I have
Okay.
a right to use the road. Okay, here's a quote from the surveyor who did the survey work for the land that I gave to Mr. Boswell. Good morning, Ray. This is May 14, 21. Good morning, Ray. I think the easement should extend westwardly to the fence. I also think it is defined as access as well to the Lewis property. This is an opinion of the surveyor
What surveyor?
who surveyed the property and identified the books and pages and easements that
Okay.
are
What's his name?
pertinent.
What's his name?
It's Brian, it's Survey Standards, Brian,
McLaughlin.
no,
Yeah,
no.
Brian who?
McLaughlin.
McLaughlin, okay, I'm not familiar with that
Also,
name.
if I
Okay,
may-
but, and again, I'm agreeing, that easement says you can go up
This-
that road, that's your easterly boundary, up and over to 37.
But
Doesn't say which one.
it does say, this is related specifically to P1 and the subdivision on P1.
That I'd like to see. I mean, that
Okay, it's down
easement,
there, right there, you see it.
it doesn't say.
Okay.
It doesn't give a distance. It just says, it just gives a direction up and a direction east, 237.
Okay, if I may quote county attorney again. The law is this: even if there is no easement whatsoever, if it's been a roadway for 20 years, it is a public highway.
Ooh.
20 years, and even Mr.
Okay.
Boswell has acknowledged that that's what the law says.
With
So
it-
this distinction of whether it's P1 or P2 or P3 is a red herring.
so now you fall back to they're all 30-foot easements. You don't combine two roads, as the prior P and Z commission informed me, as a 60-foot easement.
Well,
Two 30s doesn't equal a 60.
then I'm gonna go with Commissioner Taylor, we're adding one house.
Okay. All
But-
right.
And that was during the
I'm okay with
PUD
that.
application,
don't-
not even the subdivision
Again, I just
application.
don't feel that I have enough information to show me what road he's gonna use legally.
Okay, so let me,
With future expansion,
Pardon?
with future expansion, right? Because.
He's already
Yeah,
using
As
them.
it
Well,
is,
yeah.
as it is, it's working, right?
Oh, yeah, yeah. But it's still not a legal access. Just because you're using something doesn't give you legal access.
And I don't think we're here to determine whether or not
20
he has
years.
the legal access. We are here to determine if we say this is, can turn this into a 4-lot subdivision, our decision needs to be then, okay, A, do we allow the 4-lot subdivision? And B, if we do, is the 30-foot sufficient for building on 4 and adding any additional residences to 1, 2, and 3 without restriction?
Well, one is not possible. It already has
Or
two.
not
re-
1,
Yeah.
but 2, 3, and 4.
Correct.
Oh, okay.
okay,
Well,
let's
Correct.
have,
Okay, okay,
if
okay.
I might,
Based off of the 30-foot easement, right?
I
Of the
thought we were
30
only talking about lot 4. So we're talking about building more on 2, 3, and 4.
The potential
okay.
to. He does not want the restriction
Okay,
of not
okay.
being able to do it
Okay.
at all.
Okay.
okay, let me point this out to you. You have this plat map before you. It's probably pretty small and kind of hard to read. But if you look up here in this corner right here, it says 30-foot roadway easement, book and page. 30-foot roadway easement, book and page. Then you notice right here it says 30-foot utility dedicated hereon. Okay, here's what's happening. There's a 30-foot easement here that's not in use. This road, 36.75, is entirely on my property, entirely,
Okay,
without benefit of an easement.
okay.
So the fact is, it's a prescriptive easement. Any road that's been in use for 20 years.
Right. That road's not in question, it's access to that road.
Okay,
access to
but
that
please. So,
Well, I mean, it doesn't matter how wide that road is, it's the access to that road.
Okay, I think we're arguing in circles here.
Yes, I
So
agree.
we're going to,
We're doing public comment.
we're gonna stop here.
let's not stop. Let me at least make this point. There's
One
a
last
30
point.
There's a 30-foot easement in place. By virtue of this subdivision, I am dedicating an additional 30-foot easement. So we, in fact, will have, county minimum right-of-way is 60 feet.
That's the vertical road, sir.
Yeah, so.
Okay? We're talking east to west here.
Yeah, we're not talking north to
Oh,
south.
okay, so you carry on and I'll bring you the
Okay,
evidence.
so we're gonna stop here. We're going to open it to public comment. If you'd like to comment, please come to the podium, state your name and address, and all comments are directed to the commission, okay? You will have 3 minutes. I will raise my hand when that 3 minutes is up. I please ask you to end your comments at that time, okay?
I was gonna say, it can't be much we haven't hit on yet.
Yeah.
I'm the Mr. Boswell he's referred to on numerous occasions. My name is Ray Boswell. I live at 36800 Road P.1. Myself and most of the neighbors have no objection to the idea of turning this into a 4-lot subdivision if that will bring Mr. Lewis into compliance. We want to see him in compliance. We do ask that you do what the previous Planning Commission and the Board of County Commissioners do, is retain those restrictions on there, because the roads that we live on cannot sustain any more traffic. County Road 37, where it intersects with 184, which is what CDOT's concern is a very dangerous intersection. It can't sustain any more traffic than what we have. Nothing has changed since the last time you guys ruled on this. I hope we don't have to come back a third time. I know there were some neighbors that would have liked to have been here tonight. I think some of them thought this was all resolved and didn't think they had to come talk about it again. But I'm asking you, on behalf of myself and a number of neighbors, allow them to have a 4-lot subdivision, but keep those same restrictions in place that the Board of County Commissioners did 3 years ago. Thank you.
Thank you.
If I may.
Sir,
Mr. Lewis,
sir.
this is public
This is
comment,
public
and you
comment.
cannot,
Okay, I can respond.
Answer
Take a
at
chance
this
to
time.
respond at the end.
You will have a chance to speak. You will have a chance to speak once public comment is closed.
Well, my name's Bruce Martin. I live on P.2, 36860, right in the middle of P.2. I have signed that petition Mr. Lewis put out under the belief that we were only talking about the existing houses. Our road cannot handle any more cars. One of the reasons I moved there a year, like 16 months ago, was so that there would be no more cars coming down our road. You know, the 3 acres and all that. And I agree, Mr. Lewis has those 4 houses there. There's no reason to tear down those houses. The roads are the capacity of that. But you asked Mr. Lewis, are you planning on building more houses? He never answered that question. We don't want more houses out there. There can't be. There's not road enough for it. There's, you know, not noise. There's not parking. Why, you know, won't he state, if he wants to build more houses, tell us you want to build more houses and then follow the rules. You know, other than that, you know, the egress is for what was there. There's 6 houses on our road. It's a very small road. We take care of it in the winter. Mr. Lewis has decided to drive his tractor down the road and try and widen it out, encroaching on my land. You know, I mean, what gives him the right to try and widen the road because he wants to benefit? I mean, we're all paying the cost on P1, P2, and P3 for Mr. Lewis's benefit. And, you know, there's no reason for that. I mean, we're not getting any benefit from people coming out there. So, you know, I'm firmly asking that he has the right egress and states how many houses he's gonna build. Because, you know, right now, it's like he wouldn't answer the question. So if you wanna keep the houses the same, I'm fine with it. That's what I put on that petition. If you wanna add more houses, absolutely not. The area can't handle it. The people that have lived there for 30 years don't want it. I mean, there's no reason for it. I mean, is there water taps and all that stuff for it as well? Or will we lose water pressure? I mean, come on. You gotta think about all the costs you're putting on everybody else for his benefit. You know, I don't get it.
Thank you.
Thank you.
My name is Kathy Rousset. I live on County Road P3, and I have lived in that area since, pardon?
Your exact address, ma'am?
36665, County Road P3.
Thank you.
Yes. And I have lived there since 1975. So I have lived there. I was the only person living west of County Road 37 when I first moved there. I skied in and out. Okay, so I have seen everything that has gone on up there. All these houses have been built since I lived there. There were the hunting cabins, which were on Mr. Ellis's property. But the real issue from the ground up is that Gwen Gentry didn't get this platted as a subdivision through the county, and that has been a problem for everybody subsequent to that. So what Mr. Ellis is dealing with is fallout from that, really. But what I can tell you is that many houses have been built on all of these roads since I've been living there. And we have always managed. Mr. Ellis has done more to improve the conditions of the roads and keep them open in the winter than anyone in all the years I've been there. And I can only commend him for his consistency and his neighborliness and his help to us. He has been fabulous at helping us maintain these private roads that the county does not and should not maintain. And I would approve him having another house on Lot 4 if that's what he wants to do. He's earned the right.
Thank you.
My name is Shelley Radovanovich. I live at 36682 Road P.3. I have only been there just under 2 years, and I have dealt with Mr. Lewis several times. He has lied. He has recently, in the last month, put a sign at the end of P3 saying private road. He did it, nobody but him. So that contradicts him saying that they are all public roads. He put a sign saying no access, private road. He has what he calls at the corner of my property is 36.75, and I'm at P3. So I'm at the corner and I'm directly connected to 36.75, which I understand is not issue here. But I would like to state that he, when I first got there, lied to me about what to do to that road, and he made improvements on that road, or he calls improvements, and he put a drain pipe every couple, I don't know, 3 or 4 drain pipes on 36.7 that has directly impacted my property, which has flooded it 3 times now, because he didn't know what he was doing, and he put the pipes too high, and every time now that it rains, I get my whole half a acre is flooded. So it is my opinion that he is not capable of managing more houses, and he does, as the gentleman said, get his tractor out and go over the roads, which in actuality pulls up big rocks and makes it more difficult to drive down P3. He has done no work on the snow load at all. We have a conglomerate that has hired a gentleman who lives on the road, Roman, who has been plowing. Last year, I saw Mr. Lewis out there maybe once or twice, and he did more damage, as he usually does, than good. So it is my feeling, and I'm very concerned because I corner 36.75, that the continuation of him feeling like he can do anything he wants on P2, on P3, or any adjoining roads that we are discussing tonight is only a detriment. Plus, I might say to you that these roads, this road at 36.75 or P3 is not even 30 feet. And I am on, my property line goes across both roads, 36.75, and my property line in the front of my house on P3 also is half that road. And there is no space to enlarge those roads. There is no easement at all. Okay,
Thank you.
Good evening. My name is Andrea Martin. I live at 36860 Road P.2. As Bruce stated, my husband, we've lived there about 16 months. I agree with the issue of Mr. Lewis not presenting the truth to us as to why we were signing the petition. We were told it was because he was going to be tearing down homes, and apparently that was something from 2019. So I have a problem with falsifying that. I have a problem with more people coming down P.2, because if you look at that, there are 6 homes on P.2, and that is it. There are 4 on each end and 2 in the middle. So realistically, those are the only cars that should be going down that. As it is right now, with the amount of people that are growing in the neighborhoods, you know, FedEx, UPS, all those guys are, and I'm a 45-year logistics specialist, so I love those guys, okay? But I don't like them blaring down my road, okay? I make money with those guys. P2 will not accommodate more cars. It is nowhere near 30 feet wide. As it is right now, in the wintertime, my husband's F-250 truck doesn't fit down the road, but my Subaru can. But as it is, it doesn't fit now. So I don't know how we're going to allow more homes out there. I have no problem with the homes that are there now. I have no problem with what Mr. Lewis tries to do to the neighborhood, although I had to stop him a couple weeks ago when it rained and said, please don't plow. I can't even get my car out. I have no problem with the homes that are there. I do have a problem with more homes coming. I have a problem with taking the beauty away from Summit Lake. That's a huge problem for me, but that's all I have to say. Thank you.
My name is Edward Rosset, 36665 County Road P3. My sharing would be that the time that I've had with Mr. Lewis, he's done a job that other people haven't taken on in keeping the roads open. I will admit that, I wish at different times that the other folks could help out. And we have a group of folks that have put some money, at least on the P3 side, to keep our roads plowed at times during the winter. But my wife and I take care of 3 little grandkids, and sometimes that's early morning that we have to be out, and so the roads aren't plowed at that early in the morning. But Mr. Lewis has been one that has improved the land where his houses are. He has been neighborly with us. He shares a lot of different things, ideas with us. He takes time to elaborate on different things. I haven't heard him say something that was untruthful to us, but that's, a personal opinion that other folks would have. I feel like he's diligent. I feel like he's a good caretaker of properties that are his. He's worked on different things for some neighbors, some of the folks that haven't always been able to find housing. One of our sons rented from him for a while. Anyway, I just want to approve that it's his property, and if he's wanting to build something else on that property, that's something that we could face with a different commission. But thank you.
Thank you. Anybody else? Okay. Then we will close public comments.
May
Bring it back to the commission.
may I comment now?
Yes, just, we're not going to go through all the same things over and over
Okay,
again.
So let's distill it here. The purpose that you set here today is to determine whether it's appropriate to make a 4-lot subdivision. It really has nothing to do with additional houses. There's no application to make additional houses. My primary goal here is to get this property into 4 parcels so that my trustee can dispose of the property upon my death. Now, 40 acres with 4 houses is not really a desirable piece for most people. Not everybody wants to work 5 days a week. And so that's not the issue. Then it's inappropriate to make any conditions about the roads at this point, because according to the law and according to the county attorney, if a roadway has been in use for 20 years, it is a public highway. It is not a private easement, and these easements never were private. If you look at the language in the Exhibit A that you looked at there, it's a non-exclusive. And also, the law, Colorado law, holds that absent any specific naming of the person who is to be the beneficiary of that easement, that it is a non-exclusive easement. Now, the easements on these properties are non-exclusive easements. They are not easements for the specific use of the people whose properties adjoin the easements. The easements are, there's in the law, there's a standard in law, and there are 2 interests in an easement. One is the dominant interest, which, for example, Mr. Boswell has a dominant interest to access the highway over the properties of all the other people between him and the highway, with no distinction as to whether it's on P1 or P2 or P3 or Road 37. So it's non-exclusive. It never was intended to be exclusive. If you read the actual deeds, that they are non-exclusive. These were intended at the very beginning to be public rights of way. And they have been public rights of way for 40 years. They are not exclusive easements. I have a right to use any one of those. And the real distress, if you look at Road P1 and you look at the possibilities of what could happen here, there's really only one parcel that would likely use P1. It's this one right here. The code requires that your driveways, two things, intersect the public way at right angles. They also require that to the extent possible, that your driveways will align with the existing roads. And that's why in this situation, in the original case, the access came down through here. Instead of that, I moved this new easement right here to service these parcels. It almost aligns with P2, but not quite, which is a water meter right there.
Okay, I understand that. That's easement on the property, right?
Yes.
We have to consider the 30-foot P2, P1, P2, and P3. We have to consider that, okay? And we have to also consider that roadways have to grow with more people, right?
Well, it should.
Okay.
Hopefully we
Okay.
have
So
that we take care of that in the front
there is
end.
no room to grow on that 30-foot easement, okay? So we have to consider that growth of homes in that area poses a direct issue with the 30-foot easement.
Okay,
Affirmative.
so how many vehicles do you think would go down that road?
That's not my point. It's a 60-foot easement in the land use code,
Yes?
okay? That's the requirement for a large subdivision, okay? It's currently a 30.
Well, no, it's 60. It is it's 60 feet because there's 30 feet easement here.
That's
I'm dedicating it-
37.5.
Yes. Also, if you read the plats that I sent you, you'll realize that the property that Mr. Boswell purchased has a 45-foot easement.
Sir,
there
I'm
is, in
not
fact,
talking about,
There is in fact a 60-foot easement on P1 for the portion of the road that is where his dwelling is. Now, I'm pleased to do what I can to maintain any of these roads. And in fact, I have been working on these roads for 12 years. Mr. Haley actually thanked me for working on Road P3.
I'm not questioning your effort on the roads, okay?
Okay.
I'm not questioning whether you have good intentions on that. The question currently is whether or not to put restrictions on the 4-lot subdivision due to the 30-foot easement of P1, P2, and P3, when it is a 60-foot requirement in the land use code. Okay?
Look, we're not going to get 60-foot easement ever.
Exactly.
So we have to live with what we have, and we have to, if you rely upon the man who's in the business, the superintendent of bridges and roads in the county, and you see his opinion, he had no issue with my access to the roads.
But was that addressing what it currently is?
Yes.
What about future growth?
And again, it's the road and bridge guy. I mean, if he wants
Exactly.
to sit up here and become a
But
commissioner, then
all I'm talking about is the 30-foot, it's supposed to be 60,
Right.
it's not, it can't be, right?
Therefore, I should be prohibited from using my land. Is that the reasoning we're using here?
I'm saying it should be a consideration.
Okay, the State Highway Access Code says every property owner has a right to access the roads. It's not exclusive. It has nothing to do with the 30 feet. It's cold, it's black and white. I have a right to access the highways, and the 4 houses are already there. And I am not proposing to build a new house, and it's not within your jurisdiction to even be considering it.
It is a consideration and can be conditions upon approval of a subdivision. Okay? That happens. That's what we were considering right at this moment. Whether or not conditions should be made to the 4-lot subdivision. Okay? There's no question that the road is sufficient for what is there.
Okay.
Right?
We're not proposing to build any new houses.
Would
And
you
it-
would you like to say you will absolutely not build another house?
Absolutely not.
Okay.
This is the,
Well,
this is the very crux of the issue.
Then there's no sense in going around and round and over it again. If you have no intention to build, state you have no intention to build, and they can look at the 4-lot subdivision with what exists.
So let me understand here. First of all, you make false allegations
We're not
against
gonna
me.
rehash 4 years.
Pardon?
We're not rehashing 4 years. I already showed you what was wrong from 2019.
Okay, well, we're not rehashing 4 years, let's just rehash what you last produced.
Okay,
No, we're
hold
not
on,
gonna
hold on,
rehash it. We're
hold
not
on,
gonna
hold on.
We're-
We know what we
done.
have to consider at this point, okay? We're done, we're going to move forward.
Yes. And to clarify this, Don, we are going to be voting on whether this 4th lot can have a house, single house, and that roads, P1, P2, P3, can sustain that single house. That's it. That's it.
No,
Okay,
you're looking at approving the 4-lot
okay,
subdivision
before lot subdivision, yeah.
with the existing
With the
residences.
existing residents, okay.
Now, if you want to go beyond that with a condition, that's up to you.
Okay, okay. That's
And-
what I was after.
And we have to also consider that you can be compliant with the land use code and have or have 2 houses on a single lot.
Okay, that's true. That's
Okay.
true. Let's do that.
So then we have to consider that if we are potentially, and I'm not saying we are, but if we consider letting Mr. Lewis put a home on 4, then do we put restrictions on a second home on 4 and a second home on 2
Okay.
and a second home on 3,
Yeah.
right?
Yes,
If in fact our concern is the 30-foot access,
gotcha.
okay?
Okay.
That's where we're at.
Okay.
I'm not saying you have to do that, but that's,
No, it makes sense. It makes perfect sense. Yeah, we got too many moving parts.
yeah.
Too many moving parts.
Okay. So, at this point, I will entertain a motion.
You want to do it? Me do it.
I want some.
Okay, I make a motion that we deny this, based on that following, that we cannot put the restrictions that no more than the existing houses other than Lot 4 can be built.
Can you restate that for me, please?
That makes sense? That makes sense. huh?
No, well,
Yeah.
I'm confused.
Only because,
But you can do that. You can make those conditions.
I just need to.
we can make those conditions.
It has been done in the past. It was approved in the past, all with those same
Along with,
conditions.
say, existing, okay, then I will withdraw that
Yeah.
statement and say,
And just to be clear, you don't have to follow
You
any
don't have to put
previous
any of those on.
conditions, any previous plat notes.
but like we had said before with commissioners, if we do deny it, we have to explain to the commissioners why we're denying this.
Well, but what he's also saying is you can make a motion to approve without any conditions. Right?
Yeah,
If you feel it's sufficient and you want, or are going to allow him to build
Mm-hmm.
on all the lots up to the two building
per lot.
minimum, right? You can go with no restrictions.
Okay.
Right? You can go with restrictions, or you can choose to deny.
Okay.
If I may.
Hold on, sir. We're moving on at this point.
The point is, the county previous commission have already voted this, approved it, put conditions on it, and we're here. for the last hour and a half. So, I mean, if we vote yes and put conditions on it, we're gonna be back here. And
But that's not how you view it. You view it as is, standalone, what you
Standalone,
feel,
right,
does it
right.
meet the land use code
Does
or
it
not?
fit or not? Yep.
Now, the other thing to keep in the back of your mind is, as it sits, it's non-compliant property.
I beg to differ with you, sir.
because
I
there's
already showed that, we're not gonna rehash
Sir,
that.
it's,
there's
your
multiple
turn is over.
homes on,
There's
too
been
many
no
homes on a
finding
big lot. Yeah.
of non-compliance. In fact, the
Sir,
county
sir,
commission.
we are moved on
Well,
at this point,
well-
okay?
Boy, this is a dilemma then.
Let me take a stab at a motion.
Say again?
I said, let me take a stab.
Oh, go for it, go
At a
for it.
motion. I move to recommend to the Board of County Commissioners a proposed lot, 4-lot moderate subdivision rezoning application submitted by Ellis Lewis
Are you
based,
approving or denying?
I am proposing.
Oh,
Approval?
proposing.
Okay.
Based on the following, the proposed use is in conformity with the code. The proposed use shall not generate any significant adverse impacts on other properties in the same area. Public utilities and services are available or can be made available to support uses consistent with the proposed zoning. Conditions to the motion are that it is compliant with what the commissioners had voted on in the previous meeting, I believe was May of '21.
Okay, so just so we're clear, you made a motion to approve this on those conditions. Is that correct? Okay.
And those conditions are, can you repeat those, please?
Let me bring those up.
I think it's worth noting the conditions that weren't already met.
Correct.
I think you all have a responsibility to make your own conditions.
Sir, I'm sorry. We are on to the next portion of this, okay?
I think they only had the two conditions was lot 4 and then the.
Correct.
Well, no, there
See,
were
yeah.
three. There
Oh,
were three.
okay, I missed
It
3.
was no more building on 2, 3.
There, it's on your screen now.
Okay, include that.
No new additional
1, 2,
residences
3,
on
4,
lots 1, 2, and 3,
no new
and
CW.
plat notes on lot number 4 with no new residences be
That
built
needs-
without approval of CDOT.
Okay, that needs to be in the conditions verbatim, Jane.
Okay, so was this, what date was this, Don? I'll look it up.
It's down at the bottom. Scroll up, please. May 18th, 2021.
Okay.
Sir?
I'll put that in the
Sir?
minutes.
You gotta stop. We are moved on to this, okay?
You're not going to allow me to speak.
Then I
Not-
will,
It's, that portion's over with, okay? We have to move on.
with those conditions, I will second it.
Yeah, okay.
Okay, I will say this, gentlemen. We've just spent 3 years, and a good portion of it in litigation. And what you are proposing is directly in conflict with the United States Supreme Court rulings.
We're
Take it
not
up with
here
the
to
Supreme Court.
discuss
Take it up with the Supreme Court.
And you don't need-
Supreme
you don't-
Court
you
or
don't
the
We're
need-
done. We're done.
We're voting.
We're done.
Your only choice right now is to pull it away, pull the application, or sit and let us make a vote.
Okay. Can we call a vote, please?
no further discussion.
Oh, no further discussion on the motion? No, I'm good.
Commissioner Farian,
Aye.
Commissioner Hernandez.
Aye.
Commissioner Taylor.
Aye.
Motion was carried, vote was unanimous,
With conditions.
with conditions.
Okay, so, okay.
Please state explicitly what the conditions are.
The conditions are right here on your screen, sir.
No.
So,
No, I want you to state, this body to state what you're not rubber stamping the
okay,
county
the
commission.
conditions are no new additional residences on lots 1, 2, or 3, and the plat notes on lot 4 that no new residence be built without the approval of CDOT.
CDOT has no jurisdiction.
Those are the conditions.
This is the recommendation to the Board of County Commissioners. This is not a final decision.
And if Institute for Justice takes this up, we'll be in federal court, and these bad decisions will come back to bite you.
It's your decision, sir.
You're violating the Constitution of the United States of America.
Okay.
You don't want to hear the law, so I won't be able to explain it to you.
Roll call, please.
Commissioner Farian.
Here.
Commissioner
Here.
Hernandez.
Here.
Commissioner Taylor.
Present.
Thank you.
So for additional discussion,
Do we have any additional?
I don't know. We didn't have anything on the agenda unless you guys have.
Do you want me to?
Did those mailers get mailed out, or going to get mailed out?
Mike was directed to get that to the assessors.
Okay.
He said roughly 15,000 of them was a little over $500. So I just told him to move forward ahead with that, planning would cover that out of our budget. And I'm assuming that that will occur in November or December. Because I think those mailers all go out like in January. Because I think first payment, if you do the first half, payments due in February.
Yeah.
I think they start mailing out the mailers in late January or mid-January.
Okay.
So I mean, I don't know how many, but 15,000 was a little over 500 and some dollars, so 20,650 maybe. So
Okay, well.
I think
That's
that's
good. I'm glad
that's a
we all
good first step in getting the word
agreed on
out,
that,
just because a lot of people have moved in, and it just lets them know if they want to do something to check with us.
Yep. Okay.
Then they can verify setbacks.
Okay.
Okay.
Anything else?
Driveway permits, all sites, all sorts of conditions that,
Well, the point is to be notified, that's it. Just
Mhm.
notify that there is a code.
Exactly.
Yeah.
correct,
Stop putting your head in the sand, being an ostrich.
yeah.
Mr. Chairman, I vote that we adjourn. I move that we adjourn.
Nothing
Excuse me.
else?
Unless there's any other old business or new business.
Okay. Motion to
All
adjourn.
right, I'll second.
Okay. Vote.
Aye.
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 8:30.
Yes.
Moses.
I didn't hear.
8:27.
Aye, yeah. Pass my beer. Okay. Oh, that takes me to the